Hello, my name is Livio Zilli and I'm a senior legal advisor and one of the International Commission of Jurists' main representatives to the United Nations. I will be talking about the United Nations human rights treaty bodies. Treaty bodies are important because they are one of the most effective mechanisms, institutions under international human rights law to enhance human rights protection domestically. In these presentations, I will cover how the treaty bodies are established, their membership, their jurisdictions. I will then provide a quick overview of the main functions of human rights treaty bodies, namely the review of state parties' implementation of the provisions of the relevant treaty, the adoption by treaty bodies of general comments, and the treaty bodies' adjudication of individual communications. Let's begin with how the treaty bodies are established. Most global human rights treaties feature provisions establishing an expert body, a treaty body, to monitor state parties' implementations of the provision of the treaty and to provide guidance to states on the implementation of the treaty. Under the auspices of the United Nations, there are now 9 treaty bodies: the Human Rights Committee monitoring the implementation of International Covenant on Civil and Political Rights, the Committee on the Elimination of Racial Discrimination monitoring the implementation of the International Convention on the Elimination of All Forms of Racial Discrimination, the Committee on the Elimination of Discrimination Against Women monitoring the implementation of the Convention on the Elimination of All Forms of Discrimination Against Women, the Committee on Economic, Social and Cultural Rights monitoring the implementation of the International Covenant on Economic, Social and Cultural Rights, the Committee Against Torture monitoring the implementation of the Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment of Punishment, the Committee on the Rights of the Child monitoring the implementation of the Convention on the Rights of the Child, the Committee on the Rights of Persons with Disabilities monitoring the implementation of the Convention on the Rights of Persons with Disabilities, the Committee on Migrant Workers monitoring the implementation of the International Convention on the Protection of the Rights of all Migrant Workers and Members of their Families, and finally the Committee on Enforced Disappearances monitoring the implementation of the International Convention for the Protection of all Persons from Enforced Disappearance. With respect to the membership of the treaty bodies, each treaty sets out the number of members for its body, the method of their selection, and the body's responsibilities. The number of members varies depending on the treaty. Members are nominated by states and elected by the UN General Assembly, usually on the basis of regional balance. The members are to be independent and impartial and serve in their personal capacity. They do not represent any state, including those that nominated or voted for them. In terms of the treaty body's jurisdiction, each treaty applies only to the states that are bound by the treaty, either because they have ratified or acceded to it, determining in turn the treaty body's jurisdiction. In terms of jurisdiction ratione temporis, usually the treaty body can only deal with events that have occurred after the relevant state became a party to the treaty, or events that continued after that time. I'm now going to turn to the functions of the treaty bodies. The main functions are the review of states parties' implementation of their treaty obligations through the periodic reporting process, the adoption of general comments on the interpretation and application of treaty provisions, and the individual communications function. There are also other functions that some treaty bodies may perform and others do not, such as the interstate complaints procedure. Let's start with the periodic report function. The treaties provide a legal obligation for states to report periodically through the submission of reports on their implementation of the provision of the relevant treaty. The treaty also fixes the timing of the reports. In a full reporting cycle, there are 7 stages. The first sees the state preparing its report. This may be a time for civil society organizations to have an input in the content of the report. For example, if the state consults with them. The focus of the report is the state's implementation of the provision of the treaty. In the second stage, the state then submits the report to the relevant body. If the state fails to comply with this reporting obligation and that does not submit its report, the treaty body may decide to examine the state's record in the absence of a state report. In the third stage, having received the state report, the treaty body prepares a list of issues, which is a list of questions that the treaty body puts to the state based on the content of the state report, as well as on the basis of submissions received from civil society organizations. In the fourth stage, the state then submits its replies to the questions the treaty body has asked in its list of issues. The normal practice is for the state to file its written response one session before the session where its report will be considered. This allows the treaty body to carefully consider the state's replies and gives civil society an opportunity to provide alternative replies and comment on the state's replies. In the fifth stage, the treaty body will actually examine the state. Prior to the actual examination, there is an additional opportunity for NGOs to present written information to the treaty body in advance of the examination, focusing on their human rights concerns. The actual examination is conducted in public through a dialogue over the course of 2 half-a-days, with the state delegation presenting its report and treaty body members asking additional questions of the state and entering into a dialogue with the state representatives. Before the public examinations, civil society representatives may brief treaty body members in private. In the sixth stage, at the end of the examination, the treaty body issues a set of concluding observations and recommendations addressed to the state. The purpose of these concluding observations is for the treaty body to highlight concerns and to formulate precise recommendations to the state on how to improve its implementation of the human rights obligation under the treaty. In the seventh and final stage, there is an opportunity for the treaty body to follow up on some of its recommendations. This is known as the follow-up procedure. In its concluding observations, the treaty body may identify recommendations for immediate action. They are subject to a follow-up reporting procedure to which the treaty body requests the state party to report, generally within a 12-month time frame, on the implementations of the prioritized recommendations. The prioritized recommendations for immediate action concern issues that the treaty bodies consider require immediate attention and that are implementable within that short time frame. I will now briefly outline the second main function of the treaty bodies, the adoption of general comments, or general recommendations as they are called in the case of the Committee on the Elimination of Discrimination Against Women. The general comments may focus on a particular provision of the treaty, an article, a right, or on a theme. They explain how the treaty body interprets and applies the relevant treaty provisions and seek to assist states in the implementation of their obligations under the treaty by providing clarification on the scope and content of their obligations under the treaty. General comments are based on the treaty body's concluding observations and recommendations and on their jurisprudence. Their content may also reflect other sources of international human rights law. General comments are highly authoritative and persuasive. For example, the International Court of Justice in the case of Diallo, Republic of Guinea against Democratic Republic of the Congo in 2010 said this: "Since it was created, the Human Rights Committee has built up a considerable body of interpretive case law, in particular through its findings in response to the individual communications which may be submitted to it in respect to state parties to the first optional protocol, and in the form of its general comments. Although the court is in no way obliged in the exercise of its judicial functions to model its own interpretation of the covenant on that of the committee, it believes that it should ascribe great weight to the interpretation adopted by this independent body that was established specifically to supervise the application of that treaty." With respect to the way in which general comments are elaborated and adopted, the method varies from treaty body to treaty body. Some use general days of thematic discussions, for example, the Committee on the Rights of the Child and the Committee on the Elimination of Discrimination Against Women. The elaboration of general comments includes opportunities for the participation to varying degrees of civil society, states, and other stakeholders. I'm now going to turn to the last main function of the treaty bodies that I want to cover in this presentation, the individual complaints function. For the treaty body to carry out this particular function, the individual complaints function or individual communication in relation to a state, that state must have either made a declaration that it accepts such a function or must have ratified an additional protocol to the treaty. When this has happened, individuals may then petition the human rights treaty bodies concerning alleged violations of their human rights and the obligation of the state under the relevant treaties. The procedure is mainly conducted in written form and involves private closed meetings of the relevant treaty body, but some treaty bodies have also begun conducting oral hearings, that is, private meetings with the two parties, the states and the individual petitioning the treaty body. Each treaty body has rules of procedure governing the individual communication process. There are admissibility criteria determining whether the treaty body is competent to receive the communication. The claim is screened to determine whether it is admissible. For the claim to be admissible, the state must be a party to the principal treaty, plus it must have recognized the competence of the treaty body to receive individual communications. This must have occurred either because the state has ratified an optional protocol, as it is the case, for example, for the Human Rights Committee, the Committee on Economic, Social and Cultural Rights, the Committee on the Rights of the Child, the Committee on the Rights of Persons with Disabilities, and the Committee on the Elimination of Discrimination Against Women, or must have made a declaration under the relevant treaty, as it is the case under the Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment, the Convention on the Elimination of All Forms of Racial Discriminations, and the International Convention for the Protection of All Persons Against Enforced Disappearances. The Committee on Migrant Workers, for the Committee on Migrant Workers, the individual complaint mechanism has not entered into force yet. The other admissibility criteria are that the communication is by the victim or an authorized representative of the victim. The communication relates to one or more of the rights in the treaty. The allegations made must be sufficiently substantiated. They must concern an alleged violation that has occurred as a result of laws, policies, acts, or omission of the state, generally prior to the entry into force of the treaty, or that has continued since that time. Domestic remedies must have been exhausted. The complaint must not be frivolous or vexatious, and the complaint must not be under concurrent examination by another mechanism. When the case, if the case is deemed admissible, then the treaty body will make a decision on the merits of the case. The state concerned will be contacted for comments and for further information. The individual who has petitioned the treaty body will also be given the state response and ask for comments. The committee eventually will make a decision on the merits. Where a violation is found, the state is called to provide an effective remedy and report back to the committee. And a satisfactory outcome may be referred to a follow-up procedure. In this presentation, I have described what the treaty bodies are, how they are established, what their jurisdiction is, and what their main functions are. Additional details, including on the practical procedures and contact details for engaging with the treaty bodies, may be found on the website of the United Nations High Commissioner for Human Rights, that is www.ohchr.org. Examples of civil society submissions to the treaty bodies may also be found on the website of the International Commission of Jurists, that is www.icj.org. Thank you.